Well, hello everyone, and welcome back to One Civil Law, where, as always, we learn through the misfortunes of others. I am your host on Civil Law, a licensed attorney in Texas and Virginia, and we are here on Monday, April the 17th, 2023, with all the legal news that is happening in our world. Just a friendly reminder to all of our creators in the United States and everyone watching this, it is tax time. So just a friendly reminder, if you haven't done so already, now would be a really good time to file your taxes. So just a reminder for all those out there. We begin with some news in Alec Baldwin land. You will remember that Alec Baldwin shot somebody on a movie set and is being charged in relation to that. Of course, there are a whole bunch of civil cases as well, as you would expect, for wrongful death and other related things. And Alec Baldwin wants one of these cases to be dismissed, saying the lawsuit from the family of Helena Hutchins, the person who was shot, is misguided, even though he's the one who literally had the gun in his hands. Somehow the lawsuit is misguided. Wow. I mean, Hollywood and hubris go together, but man, damn. All right, let's learn a little bit more. Alec Baldwin is seeking to have the lawsuit against him and his fellow co-defendants from the family of Helena Hutchins dismissed. The defense filed a demurrer, which is a motion to dismiss. Some states call it a demurrer. It's the same thing. Against Hutchins' parents and her sister, arguing that they had been distant from Hutchins prior to the death. Wow. So their argument is that, your daughter and your sister died, but it's really no harm to you because you didn't like her very much. Wow, that's an interesting argument to go with, I guess. The loss of a daughter and sister is undoubtedly painful in any circumstance, yet the plaintiffs, who had been distanced from Helena physically, financially, and emotionally for years before her death, have no viable cause of action. This is an interesting way to go. Okay. So it's not that I didn't do the thing. It's not that I'm not responsible for the thing. The idea here is that you have not been harmed because even though it's your daughter who's dead and your sister who's dead, you didn't like her very much. She was a stranger to you. So why are you complaining? What difference does it make to you? That is a new one for this kind of case. I don't see that really working, and not great for the PR on that, but okay. Baldwin's lawyers added into their motion to dismiss that the action is especially misguided. Oh, especially misguided. Okay. Court documents show that Hutchins' husband promptly filed a wrongful death lawsuit after her death, and they reached a settlement. Hutchins' family, who are Ukrainians, because that matters for some reason, filed their lawsuit against Baldwin, Rust, and the film. That lawsuit alleges battery, intentional infliction of emotional distress, negligence, loss of consortium. So that's basically loss of the relationship, is loss of consortium. So that's why we haven't been hurt, because what consortium? Because you were distant strangers to her. The family's attorney described the family as devastated and claimed they were close. Apparently, Alec Baldwin would like to contest that argument that you are devastated and close, and saying you aren't devastated and you aren't close. You live all the way in Ukraine. So what? And it's, it doesn't matter. Okay. It's clear to us that the relationships of all of our clients have been damaged, and they will not be able to enjoy life in the same ways they did when their precious Helena was alive. Helena was the light of their lives. I would imagine being your daughter and sister might have some impact on you. Hutchins, who was 42 at the time, was shot and killed with a Colt 45 that was in Baldwin's hand at the time. Of course, they're still being charged criminally with involuntary manslaughter as well. They could face a 5-year sentence, but no, not so much. Because it's a first offense, they probably will not get any time, even if convicted. And Rust is currently resuming filming in Montana. So we've moved locations. I guess New Mexico has lost its lore, and we're now trying to restart the film in Montana. Thus, that brings us to the end of this discussion about Alec Baldwin's nice, interesting legal strategy, where he argues that this lawsuit from the parents and sisters don't make much sense because, who is Helena Hutchins to you? A daughter? A sister? What even is that? It doesn't matter. So you haven't really been harmed at all. You live all the way in Ukraine. So you have no feelings about your daughter whatsoever. Wow. That's a lot of hubris. And that is the end of that story. Good morning, everyone, to you. Good morning to everyone who is here to join us on this Uncivil Law Roundup, as always. Just a brief good morning to everyone as we get our story started. Martin is here. Chris, Q Squared, Nikki, Alan, Jamie. Seeing who else is here in the chat. Casey, I guess. Esquilter, WZ, Jessica, Christine, always here. Glad to have you here as always, of course. RMQM, Parallel Jen, Tammy, Kinlan, Automata, Anna, Kara, Rachel, Jillian Maloney. Glad to have you here, Miss Maloney. How are you doing this morning? Hey, Capitan, Q Squared. Thank you for the gift memberships as always. Z Zelter, Elizabeth, Ellen, Trufflehound, Cody, Crystal. Glad to have you all here as well. All right, let's go ahead and do another story. Hold on. Let me make this font work. All right. All right. Okay. The person who has been accused of this national security document leak relating to U.S. assessments of the war on Ukraine and also U.S. intelligence operations has appeared in court as the United States begins to spell out its case against the 21-year-old. A Massachusetts Air National Guardsman accused of leaking highly classified documents appeared in court as prosecutors unseal the charges and reveal how billing records and interviews with his social media friends helped pinpoint the suspect. Among revelations that were finally revealed in court, Discord provided information that helped lead the FBI to Guardsman Jack Terexia, and he used a government computer to search for the word leak on the day last week when news media reports revealed classified documents had been improperly disclosed. Friday's new details about the intelligence leak shed light on how investigators came to zero in on him, even though a motive for disclosure remains unexplained. Although the motive seems to be, let me make this bigger. Here, I want to be bigger. Even though a motive for disclosure remains publicly unexplained. The Justice Department said its investigation is continuing, and the Pentagon, which earlier this week called it a serious national security breach, is conducting its own review of access records. Teixeira, the suspect appeared in federal court in Boston to face charges under the Espionage Act, has not yet entered a plea, but the federal magistrate judge has ordered him jailed until a hearing next week. This is not just about taking home documents, that of course itself is illegal, but about transmission of those records. Everyone knows here that the documents in the end were transmitted. Yeah, because apparently he decided to share him on his group Discord, which then those people shared it with others, who shared it with others, who shared it with others, as one does. And the information, got spread around a lot, because that's what happens when you share classified information. People talk. Let's see. Apparently, his Discord group was known as Thug Shaker Central. Okay. The group drew roughly 24 enthusiasts who talked about guns and shared memes, and also had discussion on the war in Ukraine, a popular topic, to be sure. But he decided to flex his knowledge, apparently, by sharing the classified information with the Thug Shaker Central. The classified documents, which of course have not been individually authenticated because the Justice Department doesn't want to have to acknowledge more publicly than they have to, range from briefing slides mapping out Ukrainian military positions to assessments of international support for Ukraine and other sensitive topics, including, apparently, some discussion of what circumstances Russia might use nuclear weapons. That sounds like a lot of very sensitive military information. Sounds like, yeah, that sounds pretty sensitive. Sounds like he's sharing some information that probably shouldn't be shared with the general wide world. All right. That's all there is about that story. So he's in a lot of trouble, guys. He's in a lot of trouble, in case you don't figure that. Assuming he's the guy, which, it's probably the guy. Because, they were able to trace it back to the Discord group and then, ask Discord, who this? And Discord's like, here's all the information we have about him. So probably the guy, or at least one of the guys. He's that, yeah. So all is well. His name is pronounced Tashira. I'll try to remember that in the future because I'm sure we'll be discussing him more at some point. All right. All right. All right. Hope everyone's well. Glad to see Secret with Squirrels here. Sorry to hear you're still stuck in the hospital. If there's anything we can do for you, let me know. And as always, because we really appreciate you as always, and we want you to get better. And we're glad that you're here. He probably won't go to jail for life. He'll probably wind up going to jail for like probably somewhere between like 5 and 15 years, if I had to guess. But it's not going to be great. He's also going to have a real trouble getting jobs in the future. You know, I leak secret information. I'm going to have trouble in getting people to trust you. You know. Martin says, I wonder if setting up the live streams ahead of time might help with notifications. I don't know if it does, honestly, help with notifications or things like that. I don't really know how that works in terms of things. I set up the streams every morning because, well, partially for a whole bunch of reasons. One, because I'm still experimenting with what time works best for me personally. Two, I'm experimenting with the format a little bit, and I also do research in the morning for the stories I'm going to cover that day, because if I did this research in the evening, I'd miss the morning's news, and if something major breaks, I guess I don't know. But that's the way I've been doing it. But I do make sure to give like about an hour's notice. I think today technically wound up being like 55 minutes, but I do want to give at least a half hour of notification so that the Twitter bot catches it and the Discord bot catches it. And also, although I'm experimenting a little bit around the edges, people should know that I'm streaming at roughly this time, since I've been doing it for like 2 weeks. But I'm still experimenting a little bit to try to find out what works and what doesn't work and stuff like that. And, you know, we go forward with all the things. But, you know, maybe I should announce it. Maybe I should put a announcement 24 hours in advance and see what that does. Maybe that's a fair, we could try and see what happens. Maybe I should do that. So we'll see. It's not a bad idea. Maybe we'll give it a shot. But, you know, I'm not sure it really helps with, at least in my subjective experience, when I've given longer notifications, it doesn't seem to really help very much. Also, there was that video from, I think it was Spiffing Brit, who experimented with this, and YouTube doesn't seem to send out like YouTube seems to ramp up notifications as it gets closer to the time anyway. So there doesn't seem to be a lot of advantage in giving a lot of lead time, because YouTube doesn't send out many notifications if you give a lot of lead time. It seems to ramp up notifications in that half hour before. So based on that experimentation from Spiffing Brit, I'm not sure how much it would help. And also in my personal subjective experience, where I have given more notification, it doesn't seem to really help. And also it seems to like get lost. So I'm not sure, you know, it would work. And as for the time, Q squared, it should make all times local. It should make all times local. So when you look at it in YouTube, it should give your local time. That's usually how that works. But, you know, different things. Anyways. So, but I appreciate the 162 of you who are here, and the videos that we've been releasing every day seem to be working out pretty well. And the one we did on the suspect who starved to death was unexpectedly popular. Wound up being a video that was like 2 or 2.5 times, I think it was 2.3 times more popular than my normal like best video, which I did not expect. So, yeah. Legal Vices gives lots of notices and it has regular times. Maybe. I'm not sure. 3 to 6 hours prior. Well, that's really not practical because I'd have to be up at like 3 in the morning. But we'll keep working on it. Anyways, that's too much meta. Let's do another story. How much dirt do I have on my hands? Great. All right. That's better. There is now some further news as it relates to the murder of the founder of the app, Cash App, a very popular app for sending money around. The person was murdered. And now there finally is a little bit more information about the who, what, when, where, why than there was initially when I saw this first story. So now we have a little bit more information. It appears that it is Nima Momenti who apparently killed the Cash App founder over a fight about a sister. So we have a little bit more about who and a little bit more about the motive. IT consultant Nima Momenti fatally stabbed the Cash App founder Bob Lee through the heart after the pair fought about the suspect's sister and whether or not there was anything inappropriate going on. So some thought maybe that there was some sort of relationship of which Nima potentially didn't approve. And so there was a dispute over that and they stabbed him to death. So a very personal motivation, apparently. I need a brush. Might need to get a brush. That's fair. Police claim that Lee was murdered on the streets of San Francisco on April the 4th. Momenti and the slain tech entrepreneur had talked on the phone about his sister, who was married to someone else. An unnamed witness told police that Momenti grilled Lee about his sister, asking if the sister, who is married to a prominent plastic surgeon, was doing drugs or anything inappropriate. Lee, 43, assured the murderer that nothing out of bounds had happened, but apparently they didn't believe it or something. The witness told police it was unclear to them if Lee and the sister had any sort of intimate relationship that might have also been a focus for the murder. Lee had been estranged from his wife, whom he shared two young girls at the time of murder, and had moved from California to Florida. The faithful night, Momenti drove Lee to a dark and secluded area of San Francisco, where apparently they stabbed him through the heart with a kitchen knife. Momenti brought the knife from home, which police say shows this is a deliberate murder. Sister is pretty, I'll give her that. Momenti was arrested Thursday morning after exhaustive investigation, made a first appearance in court Friday, which was attended by sister and husband. He flashed a heart sign to her from okay. Momenti is set to be formally arraigned April 25th and faces more than 20 years in prison if convicted. Momenti, not Momenti, Momenti. Sorry. Police have painted a somewhat hazy picture of Lee's final hours, saying he went between the multi-million dollar high-rise apartment during the afternoon of April 3rd, where they drank along with witnesses and someone else who lived in the apartment. That apartment has, of course, also been searched by police. The witnesses said that Lee then headed back to the Tech Titans hotel room, which is when he spoke to Momenti on the phone. Video footage from the sister's apartment confirms Lee went back to the person's place in the early morning hours of April 4th. It also shows him and Momenti in an elevator together in the Ritzy building before the two allegedly got in the killer's BMW. Not long after that, authorities say grainy video captured Lee and Momeni standing outside the BMW for about 5 minutes in a deserted part of the Rincon Hills neighborhood. That is where it's believed that Momeni stabbed Lee 3 separate times. In their motion, told the suspect without bail. One of the wounds shows a directed intent to kill. One of the wounds what penetrated the victim's heart, showing a desire to kill, according to the district attorney. All right, so that's what's going on in Cash App world. Oh Lord. All right. Let's see. What else do we want to talk about today? All right, let's do this one. All right. I love you, chat. You're the best, chat. I love you, chat. And I appreciate that you love me. Did I pass the bar exam? Yes, I did. Thank you for asking. Yes, I did. I took it in July and I got results October? Yeah, October. And then I got officially sworn in December. I think it was December 21st. But yes, I did all those stuff. I completed the bar. I got sworn in. I'm a real bona fide Texas lawyer. Do you want to see my thingy that I got from Texas? Hold on. I keep it in a tube. Hold on. Come on. Come on. Come on, tube. Ugh. Alan Parker here with more gift memberships. Alan Parker has been incredibly generous with the gift memberships lately. Thank you. Okay, got the damn thing out. All right, hold on. All right, finally got it out of the tube. Very exciting. Ooh, fancy. Ooh, fancy. Oh, well, apparently it was the 15th of December since it's on the certificate. So I said the 21st, but apparently it was the 15th. Well, the Supreme Court of Texas think it was the 15th. So let's go with the 15th. Yeah. And then, of course, the other one I keep. How do I pronounce my last name? I pronounce it Mueller. Not to be confused with that other guy, Robert Mueller, who spells it the same way but pronounces it differently. I pronounce it Mueller. Was that third time passing the bar? Second time? I've taken it twice and passed it twice. Also, it's the same name as the applesauce we grew up with. Well, I'll tell you another one for Mueller. Mueller is the maker of most fire hydrants in the United States. It's true. If you go up to a random fire hydrant and you look at it, you know, it has writing on it, as you would expect. And there's a 70% chance, that fire hydrant was made by the Mueller Fire Hydrant Company. Also not related. But, you know, hey, nice to know these random these random things. Also, there's the Mueller pasta people. Am I Jewish? With a name like Kurt Mueller? That's a strange question. Am I Jewish? Kurt Mueller. That's not a very Jewish name. That's not a very Jewish name. Wow, that's an interesting one. Are you Jewish? That's fun. No. Oh, Lord. Well, I've been covering Dominion voting systems. I've been covering it a little bit. I've done some stories on it, and as things develop, I'll definitely do more on it for sure. I think Fox News is doomed. But sure, I'll be covering it. Conversion is a thing? Yes, I suppose it is a thing. I suppose I could have converted to the Jewish faith, but it's just a very strange question to ask. Why would you think that would be true? I suppose is the most logical question. What aspect of my name or personality or anything would indicate to you that I'm Jewish? Is it because I'm a lawyer? Are you one of those people that thinks all lawyers are Jewish? Is that it? Is that the thing? Just strikes me as a very strange question. But okay. Anyways, being a lawyer. Oh Lord. No. And a Lutheran would be a better bet. You know, damn. Not that it really matters in particular, but I grew up Presbyterian. But I'm not sure why we're discussing this at this point. Okay. Jim Gaffigan? Yeah, I'd look a little like Jim Gaffigan. I like to think I'm as funny as Jim Gaffigan, or even funnier. All right, let's see. It's Monday. It is Monday. That's true. I have a friend that has the last name Mueller, and he's Jewish. Okay, you got me. I have never met anyone with the last name Mueller who is Jewish. So, if you have a friend whose last name is Mueller and is Jewish, well, you got me, man. I believe Mueller might be the most common last name in Germany. So it's like the equivalent of being called Smith or something. I like my name. It makes me happy inside. While we're discussing names, why not? Because, I can give you more edification about names than you ever wanted. My first name, Kurt, Kurt, that's derived from Conrad, which is German, as opposed to Kurt, Curt, comes from Curtis, which is Greek. So calling me Curtis is actually technically and etymologically wrong. Kurt with a C comes from Curtis, Greek. Kurt with a K comes from Conrad, German. Kurt with a K, Conrad, the name means wise counselor, which is a pretty good thing for it to mean when you're an attorney. This and other name facts brought to you by Uncivil Law. I'm also not named after anybody, which is interesting, I guess. My parents thought it was a cool name. I agree. You want to know my location? I live in Austin, Texas. That's information I've discussed many times before. I live in Austin, Texas. So, that's not a secret. You were named by administrative error? That's hilarious. Are you my name? I like to think so. I like to think I'm wise. I am a counselor. I know that. The Supreme Court of Texas just told you that. It's right on the document. So, you know. Anyways, let's discuss another thing. All right, Nexion has sued Dark and Darker devs for copyright infringement in the gaming world. So this has been a bit of a news story for those of you who pay attention to gaming news with this copyright infringement lawsuit. A lot of interesting issues. It looks like more like bullying than copyright infringement, but they are suing for the copyright infringement, demanding a jury trial. So all that good stuff. Dark and Darker's legal drama is extending into the United States weeks after the feud went public. The Korean game publisher Nexion is suing Iron Mace over copyright infringement, demanding a jury trial, and two of the higher-ups are also individually named in the lawsuit. This comes just as Iron Mace releases a playtest for Dark and Darker via torrent, having been booted off Steam in relation to the copyright infringement claims. Iron Mace has yet to publicly respond, but it doesn't seem to defer the developer from continuing with the beta. In the lawsuit, Nexion isn't just trying to ensure Dark and Darker halts development and public distribution, but also calling for monetary damages for the copyright infringement. The amount the company's asking for would make up the money it says it's lost while developing its own game, P3, which claims Iron Mace stole to make Dark and Darker. So we got a whole bunch of issues here. We got misappropriation of trade secrets and copyright infringement as ideas. All right, so let's discuss some of the law that's going on here and and some of the issues. First of all, let's discuss basic legal principles. No one owns an idea. No one owns an idea. So if someone has an idea and someone's like, "Oh, that's a good idea. I'm going to go do the thing." You can't sue for that, right? You can't sue for the idea. Now, to the extent that you're taking code, to the extent you're taking graphics, to the extent you're taking sounds, to the extent you're taking assets that belong to the company, then you have a real problem. That would be the misappropriation of trade secrets idea. You took our code, you took our graphics, you took our sound, you took our other assets, but you took our idea, not so much. So the question might be, all right, where are we in this dichotomy? Is it true that they took code or not? Is it true they took graphics or not? Of course, for their part, the people that are behind this game say no, they didn't do those things. So they say that they built the code from the ground up. So we have a dispute of fact as to what's going on. So I suppose we'll have to learn more. Condoning the defendant's conduct would threaten Nexian, the video game industry, and all consumers who enjoy playing sophisticated video games. Video game developers would not be able to invest years worth of person hours into developing video games that their employee could simply transfer the employer's project files to their own personal servers. If they did that, that would be a problem. You can't take the project files. The project files belong to the company. If you did that, those employees did a bad. If those assets or that code then wound up in the infringing thing, then that would be a bad. You can't do that. Two Iron Mace employees named in the lawsuit are former Nexion employees. This is how Nexion says they got their hands on the source code and other assets, which they then claim those assets were transferred to Dark and Darker. On top of that, it's claimed that they're trying to convince employees to leave and join Iron Mace, but that's legal. You know, as long as you're not talking about a breach of contract, and almost all these things are work for hire, people can leave or not. It's just competition. So trying to say, hey, do you want to come work for my company? That's not illegal. Taking the assets, though, might be a problem. They also allege that there's a 1-year non-compete contract, although those are sometimes problematic legally. And for what it's worth, the FTC, completely unrelated to the story but contemporaneous, is taking a look at non-competes in general and thinking about maybe some sort of federal regulations as it relates to non-compete agreements, because these things tend to be a problem. A 1-year non-compete wouldn't be completely atypical and would typically be upheld, but they can be a bit problematic on the details. Even as news of the lawsuit circulates, the defendants haven't responded publicly, although it's very possible, of course, they haven't responded because their lawyers told them to shut up. So we'll see how that goes, and we'll see if we get far enough. So this is just a straight question of fact at this point. It is a straight question of fact as to whether Darker's devs took code or other assets from their former employer Nexion. If they did, that's a problem. If those codes or assets were then used and imported, then that's a problem. So there's a factual dispute here. But what they're alleging would be illegal. So the question is that what's going on, or are they simply trying to stomp down on competition? Which side of the factual dispute we're on? So something to pay attention to, and that's what it goes on for now. Why would the FTC be looking at non-competes? The Federal Trade Commission? Because non-competes, by their definition, inhibit trade. So, that stuff. This morning session's actually going better than I thought it was going to go, incidentally. I had to dig a little bit deep into the pile for stuff, and actually turned out better than I thought it did. So, you know, that's good. I am pleased. Dun, 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 dun. The issue I have with companies trying to declare ownership or deliver everything you thought of. Well, anything you produced for them, for sure. I mean, the raw idea, no. But anything that got fixed to paper, as it were, if you're an employee and you produce things for your employer owns them. So you could recreate it from scratch, because again, you can't own the idea. But that's just what it is. This is why it's good to have a regular commitment. Fair. Martin, and we got 250 people going, so it's good. Things are good. I'm in good spirits. I had a nice little party with my improv group on Friday at one of our improv members' house. A lot of fun. Worked out really well. I went to this thing called a improv jam yesterday for like an hour, which is like short form game level improv. That was fun. Kind of a free thing. Then I got class tonight. That's fun. And yeah. And I wrote the IRS a really big check, or more to the point, I did just transferred money, just suck it straight out of my bank account, IRS. Went onto the IRS website and be like, would you like to give us money? I'm like, yes, I would. How much money would you like to give us? Yeah, that's why I wasn't on Friday Night Frenzy. That's right. What app am I using for my workouts? An app called BodBot. Or is it Fitbot? One of the two. I always tag it, or I mostly tag it. Fitbod, Fitbod is the one I use. Yeah, I made the payment on Sunday. Suck it right out of my checking account. Just take it right out of my checking account. On the plus side, it wound up being about half what I expected to pay. So that's nice. One of Robert Barnes' clients, Wesley Snipes, has some great tips on avoiding paying taxes. I'm not sure Wesley Snipes is necessarily the person I would look to for advice on avoiding tax. All right. In healthcare news, a federal jury has found 3 outcome health executives guilty of 47 counts of fraud. Fraud in my healthcare industry, it's more likely than you expect. The convictions come after a 10-week trial that investigated the leader's role in a billions-dollar scheme in which the company lied to customers about how many physicians' offices their advertisements would appear in. Fun. So, billions-dollars fraud. Exciting. 47 counts of fraud. Even more exciting. Let's learn more. Of course, no. So, first, of course, there was Theranos, and now Outcome Health. On Tuesday, the grand jury found 3 former executives guilty of multiple counts of fraud. after the 10-week trial in the billion-dollar scheme. Rishi Shah, Outcome's co-founder and former CEO, was found guilty on 19 of 22 counts. Sharonda Agrawal, the company's co-founder and former president, 15 of 17. And Brad Purdy, the company's former COO and CFO, 13 of 15. Chicago-based Outcome installed screens to run educational content and advertisements in physicians' offices and sold advertising space on those devices, most of which were pharmaceuticals companies. So their plan was basically digital billboards in doctors' offices. You could have these things that would advertise products and serve as an educational tool, and that might be good. The company was worth $5 billion, but the company ran into trouble with the Wall Street Journal when it found out that the company lied to its customers about how many offices their advertisements would appear in. So how much money are we going to charge you for this advertising service might be somewhat tied to how many offices the service appears in, right? If I appear in 100 versus 1,000 offices, those are two very different numbers. And if you tell me one number and it's really a different number, that is what we call the frauds. You are lying to me for the purpose of inducing me to give you the monies in trade. That would be the short definition of fraud. The report allegedly says that the executives allowed the company to overcharge customers, as well as using falsely inflated revenue data to obtain the investments and loans. So they were lying basically to everybody. They were lying to their clients. And it's like, we're in so many places. And the clients were like, oh, that sounds good. What a deal. And then they lied to the banks about how many clients they had. And the banks were like, ooh, hey, that's good. You seem like you're a growing company. We would like to give you some money to help you further grow. Investors sued the company and got $500 million back. It's a bit of an oversight. In 2019, Outcome agreed to pay $70 million to resolve a federal financial fraud investigation and cooperate with the Justice Department. The company admitted in 2012 to 2017 the fraud scheme, but then a month later, they charged them criminally. They pled guilty to commit wire fraud and struck a deal with the government and reduced sentences. 2 other employees who reported to Deshash also pled guilty. So, yeah. So fake it till you make it, not really a great idea when it comes to business in general and specifically the healthcare executives. So these 3 executives, 47 counts of fraud, going to jail for the $1 billion fraud. That's a lot of fraud, man. That is a lot of fraud. I guess go big or go home. But in this case, go big and go to the big house. And that brings us to the end of the discussion of this story. Did you know that if you're a whistleblower and the feds get money, or if you collect on a case that has to be unsealed in which they'll know they reported to them? I didn't know that. And also at that point, I wouldn't care personally. Because money. So yes, some whistleblower programs pay. Which, that's good, probably. Like, so basically the government setting up a bounty program. Bounties are good. Government has been using bounties forever. You do have a right to confront your accusers, of course. So it's like, who accused us? This guy. So, fair. Good stuff. All right, let's do this. Let's discuss today's Florida man. which is not as exciting as some other Florida mans. I mean, we do what we can with the information that's available to us. Let's discuss today's Florida man. And then we're going to finish the stream with a serious case. U.S. Supreme Court serious. Yeah, the Supreme Court came down with a decision last week in administrative law, and I want to discuss it because we're a serious law channel. Oh, tomorrow there's oral argument in a case. I believe tomorrow is the religious case dealing with when employers have to let you off for religious observance reasons. And so Wednesday, I'm considering, well, it depends when the oral argument transcript is available because sometimes it's not always available. Sometime this week, Wednesday or later, for the morning roundup, I was considering just doing an oral argument react. So we would meet at the same time and just do like oral argument react. So could be. I thought that might be interesting. Oh, and incidentally, although we didn't really cover it today because there wasn't really much really to say, the U.S. Supreme Court put a stay on the whole abortion pill thing. So we're back to the law as it existed prior to all that. So at least for the moment, the Supreme Court put a stay, I suppose, on the original district court ruling at this point, and basically said the abortion pill can be available under the same terms as it was before. It's an emergency measure. They put it in place as an emergency measure. So there is a fairly decent chance that sometime this week, the Supreme Court will issue some further guidance on this issue. So we'll cover it then. Because the Supreme Court put in place a stay, but for how long? So we'll see. Anyways, let's discuss Florida man, and then we'll discuss U.S. Supreme Court. He theorized we should just report ourselves over and over again and collect the proceeds and pay fines using the rewards. I don't think the people who are themselves doing the bad thing can profit from the thing. I don't think it works that way. I don't think you can whistleblow on yourself and use it as a discount towards your own fines. I doubt that's a thing. Even if the letter of the law allowed for it, if you went to the court and be like, bro, the court would be like, no. Equity, right? You can't sort of profit from your own malfeasance. Employee turning the company in, I don't think you can turn them over and over again for the same exact thing and get rewarded multiple times. I think the bounty is based on a fraction of the overall proceeds. So I don't think it works that way. I mean, you could turn them in for multiple different things, but you could have turned them in for all those things in the first place. I'm not really sure there's any advantage to turning them in separately versus collectively. But then again, I haven't looked at it like super duper closely. Maybe there is some advantage somewhere. But maybe there's some advantage, but I would question that. All right. For today's Florida man, an 81-year-old Florida man accused of a nationwide fraud scheme himself fell guilty to a fraud scheme, a romance fraud. The fraudster becomes the fraud-e. Wow, fun times. Here is a picture of Florida man on the wrong side of the scam. The 81-year-old Florida man was booked Thursday after investigators said he played a role in facilitating a nationwide series of scams going back to 2021. The police department said it received reports from other law enforcement agencies, including victims of the scam in other states like Massachusetts, California, and Michigan. The scam involved the victim sending money or gift cards through the mail or payment sites like Venmo after scammers persuade the victims by pretending to be a family member or falsely telling the victims they owed money. Police say that in 2021, law enforcement was able to track shipments to the home of Bobby Crosby, who lives in Port Orange. When police confronted Crosby, he admitted to receiving victims' money and other items throughout the mail throughout a year, though he said he didn't know who was putting together the scams. However, Crosby said he was receiving the money on behalf of a woman he met through Facebook messaging the year prior. Detectives explained that Crosby deposited most of the money he received into his local bank account and typically withdrew money to forward to a Bitcoin address provided by the Facebook Messenger contact. According to police, Crosby asked police several times for the address of one of the victims so he could return the money, but at the time, he was not arrested. Police returned to Crosby's home the next month for another discussion and told them he received tens of thousands of dollars in checks, cash, money orders, gift cards, electronics, furniture, and toys. When he forwarded much of the money, he was allowed to keep a modest fee. Following the discussion, Crosby later contacted police to say he found out he'd been receiving money from an unknown female who was defrauding victims in a different part of the United States. So this basically is someone romance scammed him, and in order to please this person, he committed frauds to give this person a cut of the proceeds. Wow. According to Crosby, he usually spoke with the person on social media. Crosby also explained that he'd been told he was helping to process government funds, but the person, of course, unsurprisingly, closed their social media accounts. Police say Crosby planned to keep the money for himself if the person didn't contact him again, but upon learning about the fraud, he wanted to return the money. Police say most of the money had already been forwarded, though he was able to receive $11,000 from Crosby to return to at least one of the victims. Police report in 2022 shows that Crosby had likely been scammed himself by the Bitcoin investors who pushed him to send roughly $285,000. Wow. Crosby admitted to receiving victims' packages, though he said he didn't know who was conducting the scam. It shows that he was forwarding money to the Bitcoin address just as he had done before the year. According to Crosby, he found someone on a dating website who was responsible for sending the funds. The account told him that they had received an inheritance and wanted to move in with Crosby. It's tough out there, man. It's tough out there for the 81-year-olds trying to get the romance. All right. Let's finish off by reading this exchange, I guess. Text messages between the account and Crosby shows he was forwarding thousands of dollars he received in the mail. Let us read this text message correspondence from his fake love and Crosby. Thus, the account. Okay, honey, please probably. You might get a package by Tuesday from FedEx. And I want to help you send it as soon as you get it. Okay, my love? Crosby. How much? The account. $5,500. Crosby. Can you get some through and share with me? I'm desperate. Account. It's not mine, honey, but I'm working on something very soon for both of us. Crosby. I have about $200 left in my bill paying account, and I got mobile bills I've not yet paid for, one of them $800. Crosby. Well, you see my income. Now I get $1,647 a month, Social Security. And then every 6 months I get about $400 to $500. And then I have another source. I'm partnership with someone they're supposed to be paying me $3,000 a year for my interest in the business. So that's it. I have a little bit of pocket money, but I think very little, probably 30 or 40. I was just letting you know right up front what I'm facing. Crosby, okay, I'll get back to you. The account, okay, babe. The account, you said you need $200 to pay some of your bills? Crosby, I said that I had $200 left in my bank account. I need $2,000 or $3,000 to pay some bills. The account, that's a lot. Crosby, yes, it is. So, not all going great for Florida man over here, as he apparently was a victim of a romance scam. And to impress this woman or whatever, gave them money. But of course, it was all a fraud. Frauds built upon frauds. And that is the end of today's story of Florida man. A sad tale indeed. All right. Let us do Supreme Court. Let us do Supreme Court. All right. For today's story, we discuss the latest goings on in the United States Supreme Court in the case of Axion versus Federal Trade Commission. This is a unanimous decision of the US Supreme Court and deals with whether or not you have to exhaust administrative remedies in the federal system in order to find out whether or not the federal agency has jurisdiction in the first place. So, federal law, unlike state law, is fairly clear on this aspect. In order to sue the government, you first have to exhaust the administrative remedies that are available to you. You have to first go through whatever administrative process is available. So, depending on the agency, depending on what you're trying to do, you have to go through that process. It's only when you get to a final agency decision that you then can sue the agency. The idea, of course, being that the agency, if they can give you what you want, great. You don't have to bother the courts. And then if you need to go to the courts, you can do that. Well, there was an issue as to whether or not you have to go through the process if part of your dispute is you don't have the jurisdiction to make me go through the process. Do you have to go through the process to find out whether or not they have the right to make you go through the process? It's like a cat eating its own tail thing. And the Supreme Court said 9-0 no. If your argument is they can't make me do the process at all, then you don't have to do the process to find that out. So let's read this decision and what happened. Michelle Cochran and Axion Enterprise, respondents in separate enforcement actions initiated before the SEC and FTC, each filed suit in federal district court challenging the constitutionality of the agency proceedings that were opposing them. When, as in the enforcement actions against Cochran and Axion, a commission elects to institute administrative procedures to address a statutory violation. It typically delegates that authority to an administrative law judge, which has authority to resolve motions, hold hearings, and then issue a decision. Administrative law judge, by the way, is a executive branch official. It's someone within the agency that helps to adjudicate issues that face the agency. It's part of a typical agency review, but they are bureaucratic officials. They're not judges in the sense of Article 3. They are executive branch employees. As prescribed by statute, a party objecting to the commission proceedings makes its claims within the commission itself, and then, if needed, to the federal courts. But the parties here sidestep that review scheme, bringing their claims in district court, seeking to enjoin the administrative procedures. So the statute says, look, go to the commission, and then whatever happens, go to federal court. But they're like, wait a second, this isn't constitutional. So you have no power. So I don't want to do that. So I want to go directly to court. The individuals asserted that the tenure protections of the ALJ render them insufficiently accountable to the president in violation of separation of powers. So one of the things is these ALJs, again, they're executive branch employees. And there's been case law that's been developing on this issue and be like, look, they're inferior, what is the term? They're inferior officers. There's been case law developing on this issue, which basically is like, look, they're inferior officers. They have to be appointed by the superior officer, which is to say the secretary of fill in the blank, as the case may be, and they have to be subject to being able to be fired. So these tenure protections are actually unconstitutional because it violates the appointments clause of the Constitution. And there's definitely case law that's been developing around that area. So it's not a completely invalid argument. They also address the constitutionality of the prosecutorial and adjudicatory functions of the FTC. Each suit was premised on jurisdiction in district courts on standard federal question jurisdiction. So federal question jurisdiction just means this is a federal statute. So no special federal statute, no special federal regulation, just the generic statute that says federal courts can hear federal cases. All right, so we're doing that. So they file the suit, and then both cases get dismissed by the district court. The district court in Cochran's case held the review scheme specified by the SEC implicitly divests district courts of jurisdiction over challenges to the proceedings, which, kind of makes sense. We discussed this a little bit, right? You need to follow the administrative procedures first. The Congress says go through the administrative procedures, so you're before the wrong body. Go talk to them, and then however it works out, you can go talk to me. But we don't have the federal courts, we don't have jurisdiction right now. This is an administrative issue right now. And that included challenges to the constitutional procedures. The district court in Axon's case found the FTC Act comparable with the review scheme as it relates to that statute. On appeal, the Ninth Circuit affirmed the dismissal, concluding that they're the same type that fell within the FTC's, but the Fifth Circuit disagreed as it relates to the SEC. So these were different cases in different circuits. The Ninth Circuit said, no, the district court was right. The Fifth Circuit said, no, the district court was wrong. And so both cases get kicked up to the United States Supreme Court at basically the same time. It's a split of authority on the issue, and so the U.S. Supreme Court's asked to resolve the dispute. The Supreme Court says, the statutory review scheme set out by the FEC, let me try that again. The Supreme Court says the statutory review scheme set out by the SEC and FTC do not displace the district court's federal question jurisdiction over challenges of the unconstitutional structure. Although district courts may hear challenges to federal agency actions by way of the general jurisdictional grant, Congress may substitute an alternative review scheme. In both the cases at hand, Congress tried to do so. It provided for a review scheme about agency action in a court of appeals following the agency's own review process. The creation of such a review scheme would normally divest district courts of their jurisdiction. But that scheme does not normally extend to every claim. This court has identified three considerations to determine whether particular claims concerning agency actions are of the type Congress intended to be reviewed within the structure. First, could precluding the district court jurisdiction foreclose all meaningful judicial review? So if it would prevent the if it would prevent the district court from acting practically as a result of this, like it would be too late or whatever, then that's a problem, right? Because courts can't remedy stuff that can't be remedied as a practical matter. So if it becomes irremediable, then you might be able to go to district court first, because otherwise that would be really dumb. Next, whether the claim is wholly collateral. So if it somehow sidesteps the issue completely, then, there's that. And then whether it's outside the agency's expertise, like it doesn't belong here. The court has twice held specific claims to fall within a statutory review scheme. In the underlying case law, a coal company subject to the Mine Act filed suit in district court instead of asserting its claims, as the statutory scheme prescribed, first by the Mine Safety Commission. The crux of the dispute concerned the company's refusal to provide employee-designated union officials with access to the workplace. The company also objected on due process grounds to the agency's imposition of a fine. The court in that case held the district court lacked jurisdiction over the claims, emphasizing the commission's extensive expertise in these issues. I mean, that's what they do. They do the mining safety thing. And so the district court in that case said, hey, talk to the mine safety people about the mine safety issues. That's kind of what they do. I'm just a lowly district court. I don't do the mine safety thing, so talk to them. The court acknowledged the company's constitutional challenge was less tied to the issue of the agency's expertise, but concluded that it could be meaningfully addressed. So the mine people were like, our problem is constitutionality, and the district court saying they have expertise. No, not really. They do the mine safety. They don't have any particular expertise in constitutional law. In fact, that's kind of what courts do. The court applied the law, which involved a statutory scheme review scheme, directs federal employees charged with discharge to seek redress in the Merit System Protection Board and then in federal court. That particular individual filed suit in district court when the government fired him for failing to register for the draft. The court held the district court lacked jurisdiction, even though the issue was equal protection because of the draft exclusion of women. Although the MSPB might not hold the draft law unconstitutional, and that was sufficient to ensure meaningful review, further, the challenge to discharge was near collateral to ordinary proceedings nor unrelated. In contrast to that case, the court in different cases determined that an accounting firm's challenge to the structure of the public company accounting oversight board under the SEC landed outside the review scheme. Because not all board action culminates in commission action, the court determined that the Exchange Act provides no meaningful avenue of review. So the issue there was that you couldn't go through the administrative process because as it relates to you, there is no administrative process. This is outside the scheme. So saying go through the scheme doesn't make sense because there is no scheme as it relates to that particular cause of action. And even if the SEC took up the matter, the firm's constitutional challenge would be collateral because it's outside their expertise. So, which of these categories are we in? Are we in Merit System Protection Board, where you're challenging being fired, and so we're within the MSPB's experience? Or are we outside their experience, and so we should go to federal court first? So the court must decide which category we're in this case. Like the accounting firm case, Cochran and Axon assert sweeping constitutional claims. They assert the SEC and FTC are wielding authority that's unconstitutional. And thus, the court comes out in the case that says this issue should be resolved by the courts in the first instance. First, preclusion of district court jurisdiction could foreclose all meaningful review. Adequate judicial review does not normally demand district court involvement. The statutes at issue in this case provide for judicial review of adverse action, but in this particular case, they assert the here and now injury from being subject to the illegitimate proceedings would lead to an illegitimate decision maker. So part of the problem they assert is this is unconstitutional, and so being subject to the proceedings in and of themselves is an injury. So they have sort of this underlying thing that the FTC and FEC wants to adjudicate them on, right? So there is an interest in that issue, but the proceeding itself is now an injury unto itself, because their argument is like, wait a second, they're unconstitutional, and courts could review that, but the injury would have already happened. I would have been forced to go through the unconstitutional process, and so that can't be effectively reviewed. That injury would be impossible to remedy once the proceeding is over. Judicial review of the constitutional claims would thus come too late to be meaningful. To be sure, the expense and disruption of the proceedings do not alone justify immediate review, but the nature of the injury here is different. As with the right to not stand trial, that's effectively lost if review is deferred until after trial, for example, double jeopardy, which is one of the few instances, for example, you can appeal and say, look, you can't force me to stand trial again, double jeopardy. Forcing me to stand trial is in of itself an injury. So if you have a right not to stand trial, you can't be forced to go through trial because that would defeat the point. These people would lose their rights not to undergo these proceedings if they can't assert those rights until after the fact. The collateral nature of it also favors them. The challenges to the authority have nothing to do with enforcement-related matters, the Commission's regular adjudication, or adjudication in asserting charges against them. The parties' claims are thus collateral to whatever else is going on, because the issue is, do you have power? And so that isn't the issue of did you do a bad, right? Do you have power to review me? Finally, these claims are outside expertise because, of course, these relate to constitutional questions, which is not really within the FEC or SEC's wheelhouse. That, of course, is primarily what courts are for, so the SEC and FEC have no particular authority. Thus, reversed, and remanded by a unanimous U.S. Supreme Court. Thus, that brings us to the end of our discussion of the U.S. Supreme Court case of Axon versus Federal Trade Commission. There has been a lot of case law developing on this issue as it relates to these administrative law judges. Many agencies have them. They're not inherently improper. They're part of the review process. That's fine. But the problem has been the nature of how they get appointed and the review they're subject to. So they have to be appointed by the superior officer, which in this case is the secretary of fill in the blank, as the case might be. And then they have to be subject to being fired because they have to be subject to review under the Constitution's appointments clause. So a lot of these ALJs were improperly appointed. This was an issue that confronted the Patent Office, for example, in this US Supreme Court has dealt with this in the past. And so the SEC and FTC apparently had a very similar problem, or might have a similar problem, where these people are improperly appointed or improper review, or the structure is improper. Now, that might be a relatively easy fix for the FTC and FEC because the Supreme Court's already dealt with this in part, but you have to go fix it. And then once they go fix it, then you can adjudicate the underlying thing. But these people can go to federal court in the first instance to find out whether or not the structure is improper. So if there's a problem, the federal court can fix it. Then the FEC and FTC can fix the problem and then go from there. But that is the decision by the unanimous Supreme Court, and that brings us to the end of the decision in that case. Great. All right. You can't assert rights until after they've been trampled. Did I hear that right? I don't know what that question means. I mean, I just read the entire decision, and so I don't know. No, you didn't. So, yeah. All right. Cool. All right, that brings us to the end of our discussion today. I enjoyed our discussion today. I hope you did too. It was fun and exciting. Anything further before I end the stream? Well, let's take a look at super chats. And thank you for all the people who also bought gift memberships as well. They're always appreciated. Let's see. Today's the fourth. No super chats today. Just memberships, which is also appreciated. Thank you. Q Squared, 35 months of membership. Awesome. Thank you, Q Squared. All right. I'm going to sign off. And then I'm going to cut up this and I'm going to post some stories. That'll be fun. $10 from Sandra Ramirez. Thank you. Thank you for the pear character jumping up and down. That's nice. I appreciate that. Thank you. You'll rewatch? Yeah, you can rewatch. It's all good. It's all good. We normally are doing this at 10 a.m. every day. We were a little late getting started today. Needed a little bit more sleep, apparently. Secret McSquirrel, want you to get better soon. Please let us know if we can help. We love you. 11 a.m. works much better for me, so that's 10 a.m. Yeah, so that's fair. Yeah, I just woke up a little late today. Go to bed earlier. I went to bed at well, I also woke up. Sometimes I do. I woke up around 2. So I went to bed at 10 or 10:30, but then I woke up at 2 for a while. That happens sometimes. And so I didn't get my full night's sleep. Do I think the TikTok ban in Montana's going to get signed? Probably. All right, I'm going to sign off. It's been fun. I'll talk to you soon. Love you all. Bye.